The Mohawk Council of Kahnawà held a press briefing on Monday, April 10th to further explain the rationale of taking legal action against its sister community of Kanesatake. This comes in the midst of a complicated situation that the MCK has been trying to diffuse in the past few weeks in an effort to protect our collective interests in Tioweró, including an attached 104-acre parcel that has been effectively part of Tioweró since 1987, but not part of the Doncaster Reserve itself. KTV was at the press briefing.
Right, so the 104 acres was donated in 1987. These lands are co-owned in undivided ownership between Kanesatake and Kahnawake. However, they're held in fee simple. So these lands have never been turned into reserve lands, and because of that, a non-native is able to seize them or is able to take action against them. And so that's what makes this 104 acres different from reserve lands or property held on reserve.
We're in a dispute with Kanesatake on several fronts concerning Tioweró, in particular and more specifically 104 acres of land that was never transferred officially to the Tioweró territory. That has now become vulnerable to seizure, and to a lien has been placed on it by creditors. One in particular that it was owed substantial amount of money to by the Kanesatake councils, communities over X number of years. Not something new that just happened. So that's one of the issues and one of the reasons we have taken some actions to try and protect that territory as much as possible, the 104 acres. I guess the other side of it too is that over a 20 some odd year period, we have taken full responsibility for payment of all maintenance activities in Tioweró territory. As Chief Clinton has mentioned earlier on, we only get $15,000 a year for maintenance of roads. That's it. That's all from MINACT. In the interim, though, we have the costs for Tioweró has been $250,000 a year. All costs, including the caretakers, and the houses that are there, the homes, and everything else has gone on. On certain occasions, there's been emergencies, situations that we had to go in there, spend substantial amounts of money, using our own people, our own equipment, and things of that nature. So part of our protection recovery, if you will, is also to include the fact that there's over $1 million outstanding owed to Kahnawake by Kanesatake, and they have basically said, well, we don't owe them anything, and that their position taken on this land issue is that through their attorneys, they now have attorneys. I don't know how they're paying them when they consider that they're broke, can't pay us or pay anybody else, that their attorneys are telling them that they have a good chance, stand a chance of protecting the 104 acres, yet they've lost at just about every turn so far. So we cannot really depend on them for this matter. And we also have to look at the fact that, there's outstanding amounts that are owed to Kahnawake.
Well, we went through great means, I think, Kahnawake did, to try to come to a resolve other than where we see ourselves today. We actually went to Kanesatake and met with the entire council. Unfortunately, they did not see things the way we suggested things to be. We believed that we had the ultimate solution in terms of not risking one blade of grass or one pine needle. And again, unfortunately, they just did not see what we saw.
I can tell you that it was a last resort. From legal services perspective, the last thing we want to do is to sue another community or to go to the courts at all. Unfortunately, we were forced into that because we had run out of options. We'd asked numerous times to get an agreement or to negotiate the issues, and unfortunately, Kanesatake wasn't willing to agree to any of our terms or to even kind of agree to anything. So we've taken this action to protect Kahnawake and Kahnawake's interests and their rights. So that's why we filed the action. That being said, we can always negotiate outside of court. We can always withdraw those proceedings, and so it's not necessary that we have to go all the way through with this action.
We certainly bring to light to the fact that they do owe us a substantial amount of money. and that it protects our interests in the Tioweró territory in terms of the 104 acres. And basically, it's not what we want to do. We would rather be able to sit down and negotiate an arrangement, an understanding, and which there still is time to do. We still have time to do it like that, but it puts them on notice that we're not just going to sit back, and wait, and for them to continuously avoid, what their responsibilities are financially and politically in Tioweró.
It's always been the position of Kahnawake that, we're not going to lose one blade of grass, no more. And that the Mohawk Council of Kahnawà is going to do everything within our power to make sure that the 104 acres as a whole stays as it is. And, we'll be fighting and arguing and doing whatever we need to do to make sure that we do not lose one blade of grass.
If we're going to be at odds with each other, then let's go to the table, let's sit down and discuss it. We can always withdraw the lawsuit. That's no big deal, that.
As the media was advised, Kanesatake's council rejected Kahnawak's strategy to put a legal safety net on the 104 acres, which is located on the northern border of the territory where the caretaker's cabin is situated. At this moment, the lawsuit on the monies owed may force the Kanesatake Council to sit down and possibly find a solution to the bigger problem. In the meantime, we'll keep the community informed on any and all developments in this matter.